Hi everyone, my name's George. I'm a trainee solicitor here at the Jonathan Lee Network. I'm joined today by Kent Reynolds, one of our senior dispute resolution solicitors. So today, Kent, we're going to be discussing Section 21 notices and Section 8 notices, and basically the world about evicting tenants. So let's start off. What is a Section 21 notice?
Well, the Section 21 notice and the Section 8 notices are two legal notices that a landlord needs to give a tenant in order to legally evict them from the premises. Um, Although they achieve similar outcomes, they're very different, and sometimes it can be quite tricky to decide which of the two you're going to use.
Yes.
Basically, Section 21 at the moment, and it is subject to some law changes that may be coming through soon, is what they call the no-fault eviction system, where you don't actually have to have a reason to evict the tenant. You just have to comply with the relevant notices. There are some strict criteria on it, though. So you have to, for example, have protected any deposit that's been paid in a scheme, provided
Yes.
certain information to the tenant as to that protection. You have to have supplied an EPC certificate and the gas safety certificate. And if any complaints have been made by the tenant that result in the local authority serving an improvement notice on the landlord, that can also block a Section 21 notice being effective. You do have to give 2 months' notice, which can be also a little bit of a stumbling block, and you can't end the tenancy during the term itself. So if it's a 12-month tenancy, for example, then the landlord has to wait until expiry of that tenancy before serving the Section 21 notice. And the other important point to note about Section 21 notices is that you can't use it as a method on its own to recover rent arrears. So if your tenant does owe you rent, you'll have to bring a separate claim if you want to bring a claim to recover rent arrears. A Section 8 notice, there are different notice periods for different grounds, but generally speaking, there's a much shorter notice period than the 2 months in the Section 21 notice. It is a fault-based system, which is a disadvantage for a landlord because in some aspects the tenant can rectify the breach. So the usual ground would be 2 months or more arrears of rent. But if the tenant is clever enough to pay enough of the rent arrears that there is no longer 2 months owing at the time of the court hearing, then it's up to the judge, and it depends on the grounds. But the judge could refuse possession on the grounds that that criteria is now no longer met. So it doesn't guarantee you possession, and in some respects, it's slightly more expensive because it's a longer procedure court-wise once you get to court. So shorter notice
Yes.
period, but once you get to court, it's a more complicated and longer procedure.
Yes, thanks. So let's say if you had a tenant and they're in arrears of rent of 1 month, would it be best therefore to use the Section 21 notice system?
If you're able to, sometimes it's not possible to use it because, for example, you might still be in the inside the fixed term. Um, in which case you can't use Section 21, but you might still be able to use Section 8. But all things being equal, sometimes it works out quicker to use the Section 21 and cheaper and more effective. So it very much depends on a case-by-case basis as to which of the two to use.
Yeah, so why is it important to seek legal advice if you are considering a Section 21 or Section 8 notice? And what are the legal requirements for those notices that you need to be aware of, the key sort of requirements?
Yeah, I think it's important to take legal advice on it because it's a very technical area of law, and because obviously it's such an important thing. Somebody's losing their home, that the judge wants to make sure that they've got it absolutely right. So defects such as the wrong name being down on the
Yeah,
notice, or sometimes people get caught out by how much notice they give. If they only give exactly 2 months notice, because you can give more than 2 months, it just has to be a
of
minimum of two
course.
months. Then and if you haven't allowed for, say, the postage, the Royal Mail to deliver the notice, the court can rule that they haven't had sufficient notice. Another ground could be there are two tenants and one notice has been used for both. And one tenant may say, well, I wasn't given a copy of the notice, I didn't see it, therefore it's not valid as against me. And those are just two examples. There's lots of
Yes.
examples of technicalities that can throw the notice out. So it's important to have somebody who knows what they're doing and is legally trained to review your set of circumstances to work out not only which of the two notices would be the better route, but also that you're able to rely on that notice. Because the last thing you want to do is to serve the notice, wait the full 2 months, issue court proceedings to try and evict the tenant, end up in a court hearing many months later only to be told that it's invalid and you've got to start all over again.
Yes, that's disastrous.
That would be disastrous. And in the meantime, if the tenant's not paying rent in particular, but the landlord might still be paying his mortgage,
Yes.
Then that could be quite catastrophic.
Excellent. So what sort of documents would you provide to the tenant along with the Section 21 or Section 8 notice?
Well, it depends very much on the scenario you're looking at and if everything else has been complied with, then you would serve a Section 21 notice on its own. You wouldn't necessarily need to provide all the documentation with it. It's only when you're issuing court proceedings that you would need to show the court that you've complied with the eligibility criteria for reliance on that notice.
Yeah, so you've served the Section 21 notice and you've waited the time period you must wait, and the tenant still they're still in the property. They've refused to move out. What's the next step?
Well, the only way to lawfully evict them from the property against their will would be to issue court proceedings. It's actually a criminal offence in this country to evict, forcibly remove a tenant from a property, or even unlawfully interfere with their possession without a court order, and also an order enabling you to enforce that possession order. So unfortunately, the only option open to you is to apply to the court for possession.
And it's not like with a commercial premises where you've got a piece of re-entry clause in the lease, and you can't have that for residential properties.
Not for residential. There's extra laws there to protect tenants.
Yes, and now we know that there's going to be some reforms made to the private rental sector in England and Wales, and those are coming into force. So in your view, how will this change the Section 21 notice regime system that we have?
Well, it's going to change it quite a lot, both the Section 21 and the Section 8.
Oh, yes.
There are critics of the reforms, but I think on balance these reforms are sensible and needed. And when you look at them more carefully and don't just look at the headline in the newspapers, they are not necessarily that much of a disadvantage to the landlord, and they certainly are an advantage to the tenant. And they simplify the process and reduce costs. So yes. It's important to say that they're not law yet, and they're in the form of a bill called the Renters Reform Bill. That obviously changes can be made at any stage by Parliament before it gets passed, but most likely something of this nature is going to pass. And yes. With a majority, a big Labour majority, anything that they want to become law is likely to become law.
Yes.
And therefore, it's highly unlikely that this will not pass. When it gets passed, that's a different matter.
Yes, it's currently in the second reading at the moment in the House of Lords. So it should be relatively soon that it will receive royal assent and become law. So, and I know there's some specific provisions they have in there about rights to request a pet. So the right for a tenant to request, and they are allowed to keep a pet, which cannot be unreasonably refused. And are you have any other rules, that key things people need to be aware of at this stage?
Yeah, I think the key thing about these rules is that they're effectively abolishing the no-fault eviction process. However, there are some safeguards in there for landlords, so it doesn't mean that a landlord can never get their property back. It's there really just to stop landlords deciding that they just want to get rid of a tenant because, let's say, they're troublesome or they don't like them. So, for example, a landlord can still obtain possession of a property if they intend to live in the property themselves, or if they're selling the property in some circumstances, they can get possession that way, or if the tenant is in significant arrears, or if the tenant is causing antisocial nuisance at the property, then he can still get possession of the property.
So is it that sort of public policy argument that we should not have houses or flats for that reason left empty?
Well, precisely that. Yeah. So if a property is available to be rented and is rented, then those are the only reasons, aren't there, for a landlord to get possession back, is if they're selling it or they want to live in the property themselves. The other important point is that they are going to, according to the current bill, they are planning to get rid of the fixed term element of tenancy, so they all become periodic by default. That's going to shake up the student market quite a lot. So basically, the default position, excuse me, would be that all tenancies will be periodic and can only be ended by certain ways. There are some other changes about rent increases. So at the moment, if a tenancy is entered into for 6 months, for example, what a landlord can do is say, well, I want to keep you as a tenant in there, but I'd like a bit more rent. Thank you very much. So I'll only give you a 6-month tenancy, and I'll serve you with a Section 21 notice to say 2 months before the end of the term, purely because I want to enter into a new tenancy agreement with you at a higher rent. Now, although landlords, well, not now, but when the bill gets passed, what will happen is the landlord can increase the rent, but only once a year. That's the current proposal. Yeah. So it's a balance. The landlords can't sort of put the rent up as often as they would like to.
So they'll be able to review that rent once a year, and then they'd have to give certain notice to the tenant, so say 2 months notice.
2 months notice, so they can't just do it at the last minute, which is again common sense. There's going to be a new private renters ombudsman coming through, and that's designed to take a little bit of pressure away from the courts, because that's one of the bugbears of landlords, that it takes so long to get a claim through the court system because of court backlogs and that sort of thing. So the ombudsman is helpful. There's also going to be a portal, so an online portal where landlords will place information and tenants can then check on landlords' compliance with certain legal requirements to simplify the process. Yes. On the pets, then it's now under this new proposal, it will be illegal for landlords to unreasonably refuse a request for a tenant to come into a property with a pet, although the landlord can insist on pet insurance being paid by the tenant. So that's an element of compromise. And also there's going to be a ban on the classic advert of no benefit tenants and no children and that sort of thing.
The classic you see all the time.
You see that quite a lot, and obviously that's going to be very unfair and place difficulties on people that are just looking somewhere to rent. And one of the other changes is they're bringing the private sector in line with the public sector in terms of with social housing. There is a minimum standard that the property has to meet, and they're bringing that over so that there'll be a minimum standard also for private rental.
Yes, okay, that sounds good. And also, can you give any examples, Kent, of where you've recently helped with Section 21 and Section 8 notices?
Well, we've dealt with quite a few. No two cases are alike. They all have different issues. Just trying to think, the most recent one we had was only a few days ago when we were acting for a tenant. And there was quite an interesting legal point, is that the agent had made a mistake, the letting agent, in that they prepared the tenancy agreement, which is obviously quite normal, but they put themselves down as the landlord instead of the actual landlord.
Oh.
And then to make matters worse, that company had actually been dissolved by the time of the Section 21 notice. So company didn't actually exist.
Yes.
Which was a bit of a problem for the landlord. So the landlord had to argue some elaborate argument about a subtenancy being granted, and it was all a mistake, and different legal arguments. In the end, the case settled, and the landlord ended up paying some compensation to the tenant for some of the tenant's claims. The tenant was claiming damages because of damp and other disrepair issues on the property. So the landlord had decided just at the last minute it wasn't worth rolling the dice. It was literally outside court that it settled. Yes. And the landlord decided not to roll the dice on potentially having the claim fail, and decided to pay compensation in return for the tenant being given a reasonable opportunity to find an alternative premises.
Yes, and I suppose that really showcases why competent legal advice needs to be sought out at the outset, especially
Absolutely. That could have been avoided.
Avoid any issues.
Very expensive mistake for the landlord,
Yes.
Unfortunately.
Yes, no, that's brilliant. So, yeah, it's been really good to discuss Section 21 and Section 8 notices today with you, Kent. And do you have any further points on the whole process?
I think on sort of the political side of it, it is a benefit for landlords in the sense that it's going to weed out the rogue landlords and improve the reputation of the industry. And if you're a law-abiding, decent landlord, then you don't want the industry to be tarred in that way by rogue landlords, and it will probably strengthen the whole renting system. I mean, that's the aim of it. Obviously, everything, the proof of the pudding is in the eating. We'll see how, and it will have its critics. Some of the criticism is that it's going to make perhaps rents even higher, because landlords are going to, first of all, some landlords might be put off and start selling their stock. Secondly, they may, in anticipation of the new law, put the rent up, and that's not going to be helpful for tenants. Plus, if they start selling their stock, that's going to put prices up purely because of supply and demand, and there's going to be less housing out there potentially. And it may be slightly more inconvenient for students, because it may take a certain amount of student accommodation out of circulation because of the ban on fixed-term tenancies.
Yes, yeah. So removing the periodic tenancies for, removing fixed-term tenancies for students cause some issues.
Yeah, because fixed-term tenancies were lawful for everybody, but it's particularly going to hit the student market. We think, but obviously we'll see. We don't know which parts of it are going to come into law. Technically speaking, we don't know if any of it will become law, but it's most likely that it will, just simply because of how far it's progressed. This level of detail, it's very rare for there to be a complete U-turn, and I think there's the political will for this to go through.
Absolutely. So yeah, it remains to be seen how it will be,
how it will pan out, and how it will affect the market. Whether the doomsayers are correct.
Yes, well, if anyone has any Section 21 or Section 8 notice issues, yes, we would be more than happy to assist.